So earlier this week, you may have seen the story about former Department of Justice attorneys who projected the John Adams quote onto the building, the Justice Department building, and it was a government of laws, not of men. It was courageous, it was very clever, and it captured one of the most important principles in our constitutional system. Because no public official is supposed to be above the law. But apparently, VA Secretary Doug Collins and the acting chairman of the Board of Veterans Appeals, Ken Arnold, missed that middle school civics class. Because in March, Judge DuBose ruled that the Department of Veterans Affairs had unlawfully stripped federal employees of collective bargaining rights and retaliated against unions for protected advocacy. She ordered the VA to restore the status quo ante, and that included restoring our collective bargaining agreement, the master agreement, as well as all supplemental agreements and all memoranda of understanding or MOUs. But instead of simply complying, VA leadership began playing games with the ruling. VA claimed it recognized the master agreement while still refusing to correct employees' bargaining unit status codes on their SF-50s, which was a really cute move. Judge DuBose was then forced to issue another order reminding VA that compliance was required in both form and in substance. So Doug Collins then corrected our SF-50s. He did restore our official time, which allows union stewards to represent employees, and he returned our office space. Sounds pretty good, but the non-compliance for major issues affecting VA employees still continues. Secretary Collins, who is an attorney himself, took an oath to uphold the Constitution and to faithfully execute the law. He continues refusing to fully restore telework rights negotiated under that collective bargaining agreement. But even worse, employees with disabilities, many of them veterans themselves, so disabled VA employees that work for him, continue facing efforts to terminate or restrict long-standing telework accommodations despite no meaningful change in their medical condition or their job duties. This is not just a labor issue. That raises serious concerns of disability discrimination under the Rehabilitation Act. And at the Board of Veterans Appeals, the acting chairman, Ken Arnold, also an attorney, continues refusing to restore the negotiated attorney performance standards as required by Judge DuBose's order. And now we face another problem. The First Circuit Court of Appeals recently affirmed Judge DuBose's injunction, which is good news for us, but stated that ongoing labor disputes, like the ones I just mentioned, should proceed through the normal grievance and arbitration process. However, at the same time, the Federal Mediation and Conciliation Service, which is the agency responsible for providing lists of arbitrators so our disputes can move forward, they are now refusing to process arbitrator selections involving all VA cases. So basically, employees are effectively being told, take your disputes to arbitration while the machinery needed to obtain arbitrators is itself being blocked. We must now rely on government officials like Secretary Collins and Ken Arnold to behave honorably and to respect the rule of law. But don't hold your breath, because behaving honorably requires that when a federal court issues an order, public officials will comply with it in good faith, even when they disagree. So for you, Mr. Secretary and Mr. Arnold, I repeat what John Adams said. We are a government of laws and not of men. That principle still matters. At least I hope it still matters. And by the way, the organization behind that projection is called the Justice Connection, and I encourage you to check out their work on their website.